I'll have to raise my voice. Okay. No, thank you. Sorry about that. I'll then try and raise my voice, or if possible, come closer, if you're able to come closer. Let me start all over again. I'm saying that Dr. Neil Aggett, a 28-year-old medical practitioner turned trade unionist, died on the 5th of February, 1982, was being held in custody at the then John Foster Square police station in terms of Section 6 of the Terrorism Act. His lifeless body was found hanging in cell number 209 on the second floor. A scarf or cloth of Kenyan origin was found around his neck and tied to the grill. Neil was the youngest in the family of three. He was born in Kenya in the year 1955. The family emigrated to South Africa early in 1960 and settled in the Cape Colony, where the young Neil later qualified as a medical practitioner in the year 1976 from the University of Cape Town. During his days at the university, he met an equally human rights conscious medical student, Elizabeth Floyd, Liz. A romantic relationship developed between them, and after Neil qualified, the two of them lived together in a cottage on a wine estate in the Cape Colony. Liz told the court that it was a simple home with no electricity. Neil was against taking part in the military activities of the South African Army, having seen how they dealt with the 1976 Soweto Youth Uprising. He became a conscription dodger. He left Cape Town and settled in Johannesburg, where he joined the trade union movement for no salary, whilst working part-time as a medical practitioner at the then Baragwanath Hospital, as well as other clinics in Soweto, including Tembisa Hospital. It was during this time that he met a number of trade union and human rights activists, amongst them Oscar Mpeta, Frank Chikane, Maurice Smithers, Barbara Hogan, Parmanath Naidu, Firoz Kachalia, John Theron, and others. It is that association that attracted the attention of the security branch police to him. Liz had by then joined him, and they both lived a modest life in a flat in Fox Street, Johannesburg. Liz had also in the meantime become qualified as a medical practitioner. It seems that it was their style of living which the security police could not understand, why a young white couple with good qualifications chose to abandon all privileges that were available to white people and associated with people who, according to them, were intent to topple the white minority government. On the 27th of November 1981, in the early hours, Neil and Liz were arrested while spending the night at a friend's place in Crown Mines. Liz was taken to Hillbrook Police Station, whilst Neil was taken to Pretoria, and later to John Foster Square, both in terms of Section 6 of the Terrorism Act. They never saw each other again. On the morning of the 5th of February, 1982, the security police announced that Neil had committed suicide by hanging himself in his cell overnight. When the news was broken to Liz at about 10 in the morning, she screamed, I quote, "You killed him," referring to the security police. That has indeed been the belief of not only the progressive South African community, but also international organizations. His death in detention drew widespread international attention and condemnation that had not been seen since the death of Steve Biko and Ahmed Timol, both in detention. Workers downed tools. Commemoration rallies were organized, addressed by prominent community and human rights activists, amongst them the late Bishop Tutu at Wits University and elsewhere. Neil was the first white person to die whilst in police custody. In the Citizen newspaper of the 8th of February 1982, it was reported that General Mike Helden Hayes, the then Commissioner of Police, had released a statement that, quote, Dr. Neil Aggett, 28, the Transvaal Secretary for the Food and Canning Workers Union, was found hanged in his cell at Security Police headquarters, and everything indicated he had taken his own life. Close quotation. An inquest was held in 1982, presided over by Magistrate Kotze, who found that no one was to blame for the death. Courts accepted the version of the police despite overwhelming evidence to the contrary. That finding was never accepted by the family, the international community, and the large friends and colleagues of Neil. It left the family devastated. The legal community asked questions. Newspapers reported widely and condemned the finding. It was, to the South African government, business as usual, starting with Timol, Biko, Mapetla Mohapi, etc. They all took their lives to withhold information and protect their friends who were organizing a revolution to take over the government. With the advent of the democratic dispensation in South Africa in 1994, renewed attempts were made to find the truth about Neil's death. The law firm Weber Wenzel, duly assisted by private investigators as well as counsel, went about gathering evidence which enabled them to approach the National Director of Public Prosecution with information that had not been available or had not been properly considered by the magistrate who conducted the inquest in the year 1982. The Office of the NDPP made recommendations to the Minister of Justice and Correctional Services for a reopening of the inquest in terms of Section 17A1 of the Inquest Act 58 of 1959. After some years, it was only when the present Minister of Justice, Honorable Lamola, took office that the matter was expedited. The Minister in turn issued a directive to the Judge President of this division to designate a judge to preside over the reopened inquest. This is the second such inquest, following that of Ahmed Timol, which was presided over by my brother Mote during the year 2017. It was brought to my attention by the evidence leader during the pre-hearing meeting that because of the long wait since 1994, some documents had gone missing and attempts were being made to search for some in archives. Some witnesses, especially those involved in the arrest and detention period, had passed away. Despite these shortcomings, it did not deter the evidence leader to proceed and present available evidence in the form of affidavits in the first inquest, as well as affidavits by persons who had been detained prior to and during Neil's death. Some former detainees not only deposed to affidavits, but availed themselves freely and gave oral evidence before this court. This court is indebted to all of them, as it is their evidence, which was widely publicized in the media, that assisted in informing not only this court, but the general public as to what exactly used to happen on the 10th floor of John Foster Square those days. One of the detainees, Naidu, told this court that during his torture, the security branch officer told him that the 10th floor, which they referred to as Timol floor, will be renamed Naidu when they are finished with him. David Smuts, a Namibian judge, in his book titled Death, Detention and Disappearance, writing about activities of Kufut, a South African police unit, as to how they treated SWAPO detainees and other insurgents in the 1980s, writes as follows, I quote, "A system of torture was central to political trials, and for that matter, to detention without trial in Namibia in the 1980s. Not only were the defendants subjected to torture to extract confessions and admissions, but witnesses were also detained and tortured. This was because there were frequently civilian collaborators who would be tortured to incriminate insurgents and other civilians collaborators who would then be charged under the Terrorism Act. Once information was coercively obtained from witness detainees, they would be threatened with prosecution or further incarceration unless they testified along the lines of what had been extracted from them by third-degree methods. Almost all defendants ended up making confessions and admissions after undergoing grueling torture. The Sharpeville massacre of March 1960 had opened a new chapter in the history of political violence in South Africa. It led to the banning of the African National Congress and the Pan-Africanist Congress. It is those bannings and resultant torture of their members that drove thousands of South Africans, even those not aligned to the two political movements, to leave the country and go into self-imposed exile. The late Advocate George Bizos, a renowned and well-respected human rights lawyer, writing in his book, No One to Blame, said the following: The acquittal of the political leaders at the end of the treason trial in 1961 probably marked the end of the administration of justice in accordance with generally accepted procedural safeguards such as habeas corpus. And when the African National Congress embarked upon the armed struggle in 1961, in December 1961, it gave Foster the excuse he needed, if indeed one was needed, to introduce detention without trial. The Sabotage Act of 1962 was passed to allow house arrest despite heavy criticism, mainly from organizations such as the Congress of Democrats and the Black Search. In 1967, Section 6 of the Terrorism Act empowered the police to prolong detention without trial for an indefinite period. Generally, a prisoner is at the mercy of his or her captors. That is why in most civilized countries, procedural safeguards have been introduced such as visits by doctors, senior officers, and members of the family, and the companionship of fellow prisoners. Detention without trial in South Africa did away with all that. Even judges who had the right to visit prisoners at any time were effectively excluded from visiting political detainees. No wonder many detainees died in detention. The only witnesses to the circumstances of their detention were policemen or prison warders, but the shots were called by the security police, who were charged with ensuring the safety of the state and were a law unto themselves. They could hold detainees for as long as they liked, keep them awake by working shifts, deprive them of reading material, and isolate them from the community. Close quotation. It is common cause Neil was a dedicated medical practitioner and trade union organizer. In his own words, he was an idealist. He only wanted the best for his country and identified with the oppressed people of South Africa. He was deeply offended by the inequalities imposed on black people and other people of color under the apartheid system. Neil chose to use his skills, his education and energy to make a meaningful difference to the oppressed, and in this regard, he chose to intervene as a doctor/trade unionist in the areas of health and care. When the ANC leadership went into exile and others arrested and jailed, those left inside the country recruited others to start mobilizing. One of those recruited was a young student activist, Ms. Barbara Hogan. Maria Skoon and Jeanette Curtis, who were in exile and based in Botswana, instructed Barbara to set up a dead letter box. If she needed to report anything to Marius and Jeanette, she would do it in writing and leave such document at a certain place where it would be picked up by an ANC courier person who would then take that document outside the country. Barbara opened a post box under a false name in Johannesburg. She had been taught how to encode documents. As a result, any document she sent out used codes, not actual names. And the courier, who she did not know and never met, had a duplicate key to the box. Ms. Barbara Hogan was at that time involved in support work for the trade union, as well as consumer boycotts and various other community-related activities. She met Neil and Liz whilst all three worked for the Industrial Age Society in the late 70s. It was at that time that National Intelligence, a separate structure within the security police branch, started following up on the activities of all the white people who were either sympathetic or actual members of the banned ANC. Barbara became a target and was being followed. During or about June 1981, and in the process of carrying out instructions from the ANC in exile, she was asked to compile a list of the names of the persons in the country with whom she was working. She did so and compiled a list which she titled Close Comrades List. The document itself had 3 categories. The first 3 names were those of Cedric de Beer, Gavin Anderson, and Orat van Heerden. She indicated that she met with the 3 regularly, and all 3 were deeply committed to the ANC. Then followed the names of Frank Haysom and Alan Fine. Alan worked in the trade union movement and was a good friend of Maria Skoon and Jeanette Skoon. The last group, which she titled to be a reference group, consisted of Neil Aggett, Liz Floyd, Merle Favis, Mohamed Vali Musa, Ismail Momoniat, and Monty Narsu. It is this last group that she says she strategized with in the trade union movement. She valued their opinion, their wisdom, as well as their experiences and insight in working with people. To her, they were an advisory group, and she never discussed ANC activities with them. She also never tried to recruit them to be ANC members. This last group was only engaged in consumer boycott issues in support of trade union workers. Their work was legitimate and above board. The last group consisted of Barbara Creasy, Barbara Klachman, Joanne Yaviton, Joanne Smithers, Neil Coleman, and Jane Barrett. These were a younger group of activists who, post-1976, became very committed and involved in organizing the black working class. That list, titled Comrades List, Close Comrades, was intercepted by the security police. And on the 22nd of September 1981, Barbara Hogan and Barbara Klachman were arrested. The raid and arrest was carried out by one Major Arthur Benoni Cronwright, whose name would later appear prominent in the detention. He, Major Cronwright, according to Barbara, was a very aggressive and extremely angry person. His staff referred to him as Hitler. Acting on this list, the security police followed Neil and Liz and watched their movements and ultimately arrested them, both of them, in the morning of the 27th of November 1981. As I indicated earlier on, Neil was taken to Pretoria, whilst Liz was taken to Hillbrow Hospital and later to Bronkhorst Parade, South African police. And they never saw each other again. The inquest, including the this reopened inquest, is regulated by Act 58 of 1959 as amended by Section 1 of Act 145 of 1992. The purpose of holding an inquest is to investigate the circumstances of death that occurred from other than natural causes and where prosecutors declined to prosecute. Section 17A1 of the Act provides as follows, I quote, "The Minister may, on the recommendation of the Attorney General, consent, and at any time after the determination of an inquest, and if it deems it necessary in the interest of justice, request a Judge President of a Provincial Division of the Supreme Court of South Africa to reopen that inquest, whereupon the judge thus designed shall reopen such inquest." During or about June 2016, the pro bono department of the law firm Weber Wenzel, acting on behalf of the Aggett family, threatened National Prosecuting Authority with litigation to compel them to reopen the inquest. This threat fell on deaf ears. 3 years later, during April 2019, Minister Lamola announced the reopening of the Neil Aggett inquest. This happened during the same week when one of Neil's interrogators, Warrant Officer Stephen Whitehead, passed away. Evidence will show that Warrant Officer Stephen Whitehead played a major role in events that eventually led to Neil's death. It is accordingly regrettable that he was not there to put his version of events. This reopened inquest is neither an appeal nor a review of the initial inquest held in 1982. It is, however, a reconsideration of the entire evidence considered by the initial inquest at the time of death, which for one or other reason was not or could not be considered during the initial inquest proceedings, and has now become available. It is common cause I've indicated Neil and Liz were detained in terms of the Terrorism Act. That act defined terrorism as anything that might endanger the maintenance of law and order in the Republic of South Africa. It authorized detention of persons for a period of 60 days, which is renewable at the pleasure of the security police for purposes of further interrogation. It was only the Commissioner of Police, subject to the directives from the Minister, who was authorized to release such detainee when satisfied that such a detainee has satisfactorily replied to all questions at the said interrogation, or that no useful purpose will be served by that detainee's further detention. Section 6 prohibited access to detainees and excluded judicial intervention by the courts to inquire into conditions of detention. It placed the well-being of detainees completely at the mercy and discretion of security police officers who were a law unto themselves, And when anything happened to the detainee, they were the only eyewitnesses to such occurrences and could do as they wished with the quality of evidence they chose to present to the courts. At the beginning of this reopened inquest, this court and the evidence leaders conducted an inspection loco at John Foster police station, especially the security branch offices, including the detention cells. The following was recorded. The second floor comprises of a number of solitary confinement cells. It is a square building located at the rear of John Foster Square and comprises of 3 floors. 3 of the right-angled corridors are for male detainees. The further one is separate for female detainees. Black and white detainees were locked alongside each other. There are 2 ways or routes to access the security cells, including the interrogation offices located on the 9th and 10th floors. The first is via the main charge office. Then you walk to a flight of stairs on the ground floor. These stairs lead you directly to the second floor. The second route is via the parking garage at the back of the building. The second floor, as well as the 9th and 10th floors, can also be reached via a separate lift situated at the ground floor close to the flight of stairs. When one reaches the second floor, either via the lift or the stairs, there is a locked gate at which is a black security guard who will then open for you to proceed to a separate charge office where a register is kept to sign your name and your reasons for being there. There is in that charge office an inventory room where all personal items of detainees were kept and recorded. An officer is in charge of that, and when a detainee requires something, it is recorded in a register which is kept in that room. There is also a consultation room which was used by the medical practitioners as well as magistrates who came to consult with detainees. There is an open area on the second floor which is used as an exercise area for detainees under supervision. Each cell on the second floor comprises of a solid door and an inner grille. The grille is about 1 meter away from the solid door. The grille is locked with a normal lock as well as with a padlock. The officer who is stationed at the entrance of the second floor cells keeps the key to the cell door, whilst the padlock key is kept by the white warrant officer in charge, and when he knocks off at 16:30, that padlock key is kept in an office in the main charge office on the ground floor. Inside each cell is a toilet, a hard cement bed, and a blanket. The solid door on the outside of each cell has a peephole through which the officer guarding the detainees will peep to see if a detainee was still inside or not. At the inspection loco, the court observed and was informed that access to the second floor cells could also be accessed via a corridor behind the charge office without anyone noticing. The diagram depicting the second floor also indicates that there is a gate opposite second floor cell B24A, which leads directly to the staircases descending to the first floor cell A52, which route bypasses the second floor charge office. The 10th floor, where all the interrogations took place, was strictly occupied by members of the security branch and was accessed via the 9th floor using a dedicated lift. Entrance is through the parking garage. There is always a security branch officer sitting inside the bulletproof glass cubicle. The 2 dedicated lifts to this floor compulsorily stop on the 9th floor. There are 4 other lifts that service the rest of the building. The 10th floor, which was aptly known as Timol Heights, named after Ahmed Timol, a detainee who was pushed to death from that floor during 1971, houses a number of offices where interrogations took place. It also, according to witnesses, had a room called the Varakammer, truth room. It is structured in a way that it is noise-proof. Evidence by Maurice Smithers, one of the detainees at the same time as Neil, revealed that Neil was seen in office number 1012 performing exercises. He could see that from office number 1012 where he was taken for questioning. And now deal with events that Dr. Aggett's involvement activities that led to his arrest and detention. Shortly after qualifying as a medical practitioner, Neil worked as an intern at Umtata Hospital. He later moved to Tembisa Hospital. It was during this time that he developed an interest in trade unionism. He and Liz lived together in a flat in Fox Street, Johannesburg. He had made up his mind that he will not undergo military training. Whilst working at Baragwanath Hospital, he developed an interest in emergency surgery, probably as a result of what he was exposed to at that hospital. Oscar Mpeta, a South African trade union leader and founder member of SACTU, came up to Johannesburg from Cape Town to open a branch of the Food and Cannery Workers Union. He stayed with Neil and Liz, and in the process recruited Neil into the trade union movement. Neil was later to be mentored by, amongst others, Emma Mashinini, who ran KAU, as well as Tozamile Kweta and Susan Jikelana from a sister union called SAU. Neil's interest had developed, and he began to work full-time in the emerging labor movement whilst working part-time at Baragwanath Hospital. And whilst working as a part-time union organizer, he was not paid any salary. It was this association with the trade union movement that drew the attention of the security police to him and Liz. Lieutenant Whitehead was assigned to follow and watch his and Liz's movement. Amongst the people that he had come into contact with, as I indicated, was Ms. Barbara Hogan, an underground member of the ANC. Barbara Hogan, as she testified, was tricked by the security police, and the list of close comrades that she had complied for the information of the ANC in exile landed in the hands of the security police. In the list, Neil's name was there. Barbara was arrested, and whilst in detention, Neil and a number of other trade unionists and underground ANC members were taken into custody in a security swoop during November 1981. In the mind of the security police, they had cracked the inside operation of the ANC, and they were now ready and preparing for the second and biggest treason trial since the 1956 treason trial. Major Arthur Cronwright, the then head of security police at John Foster Square, was desperate to use the close comrades list to prove a wider conspiracy. In the list, Neil was described by Barbara Hogan as belonging to the advisory reference group and was never referred to as an ANC member. Captain Martin Nodier was the first to interrogate Neil from around 15th of December 1981 till about the 23rd of December 1981. He came from East London and was relieved of that duty early in January 1982. His evidence in 1982, as well as in the reopened inquest, was consistent. He could not link Neil with any involvement with the banned ANC or SACTU, and according to him, Neil should have been released. Lieutenant Stephen Whitehead took over interrogation of Neil from January 1982, shortly after Captain Nodier had left. He, with the assistance of one Skalkvik, a railway police officer, intensified interrogation from that period until the death of Neil. Whitehead had come to the conclusion that the statement made by Neil to Captain Nodier was insufficient, hence he intensified effort to get a confession. Whitehead passed away in the year 2019. Johann Nicholas Fesser, together with Captain Swanepoel, interrogated Neil on the 30th of January 1982 from 6 a.m. to 6 p.m. Fesser occupied an office on the 9th floor and was in control of the 9 white departments dealing with ANC matters. Joseph Petrus Woensdracht, together with Whitehead and Nicholas Johannes Dietlefs, interrogated Neil on the 30th of January 1982 from 1800 hours until the following morning at 3 a.m. of the 31st of January 1982. Magezi Eddie Chauke, who joined the security branch during November 1981, was also stationed at John Foster Square. His duty was to escort detainees from their cells on the 2nd floor for interrogation to the interrogation offices on the 10th floor and back. He at times sat with Whitehead and Skalkvik during Neil's interrogation. He told the court that he did not take part in interrogation and merely sat there at times reading a newspaper. The 1982 inquest judgment indicates that, all in all, the deceased Dr. Neil Aggett was interrogated by 14 security police officers who took shifts that culminated in the non-stop 62-hour interrogation that commenced on the 28th of January 1982 until the 1st of February 1982. This interrogation was authorized by Major Arthur Cronwright. I now deal with the proceedings in the 1982 inquest. The procedure about checking on detainees in their cells was narrated by, amongst others, Constable Museu Posehlo. He was a constable stationed at John Foster Square in the security branch office. He reported for duty at 2100 hours 45 on the evening of the 4th of February 1982. And at 2200 hours, he accompanied Sergeant Achenbach and Warrant Officer Murray on an inspection of the cells on the second floor. He testified that both Achenbach and Murray entered cell 209 and spoke to Dr. Aggett, who told them that all was in order. He closed the door and they left to do inspection of other detainee cells. Sehlo testified that at about 11 p.m., he alone went on an inspection of the cells, but this time he only peeped through the opening of the door. He noticed Dr. Aggett lying on his bed reading. At 1:30 a.m. on the 5th of February, he accompanied Achenbach on an inspection of the cells, and after opening cell 209, Sergeant Achenbach went in and then called him, and he saw the body of Dr. Neil Aggett hanging on a scarf from inside the grill door. Warrant Officer Murray was then called. Sehlo testified that in terms of the standing orders or procedure, he is supposed to peep through each cell door at 1 hour intervals. When asked why on this particular day he did not visit the cells at midnight and at 1 a.m., he answered that, and I quote, "I thought everything was still in order because those detainees were not troublesome," close quotation. Something happened to Dr. Aggett between 2300 hours on the night of the 4th of February 1982 and 1:30 a.m. on the 5th of February 1982. The 1982 inquest was tasked to find out if his death was caused by any act or omission on the part of any person and to make a finding therein. Of importance, Constable Sehlo under cross-examination confirmed that at times the security police do come at night to take away detainees and bring them back in the morning. But on the night of the 4th of February, no security officer came there to remove any detainee. He did not know Warrant Officer Stephen Whitehead. At the conclusion of the hearing before Magistrate Kotze on the 20th of December 1982, Kotze made the following findings in concluding that Dr. Neil Aggett committed suicide. 1, that Neil was a man devoted to a cause and worked with a number of close associates to achieve his goal. 2, that during the period of detention, Neil disclosed particulars of his activities and, more important, names of his associates. 3, that the disclosures must have brought about a feeling of uncertainty about his future and the realization that steps could be taken against his associates. Also, the possibilities of a sense of guilt towards his associates, a sense of betrayal of his friends and associates. 5, that he had to face some of his associates and to admit their disclosure and anticipation of feeling of rejection by them could not be excluded. In the final analysis, the Magistrate Kotze concluded that Dr. Aggett's death was not brought about by any act of omission involving or amounting to an offense on the part of any person. Evidence presented on behalf of the Aggett family, which included sworn affidavits by fellow detainees, was to the effect that Dr. Aggett had been subjected to intense interrogation, which included a continuous period of 62 hours of sleep deprivation and assault and torture that drove Aggett to suicide. It was argued that Major Cronwright and Lieutenant Stephen Whitehead knew that suicide was a likely result of the unlawful conduct and took no steps to prevent this when, in fact, it is their duty to safeguard detainees. In dismissing the version presented by the Aggett family, the magistrate accepted the version of the police that Aggett was well and in good condition and decided to take his life because he had a sense of guilt. He had a sense of guilt that he had exposed other people to arrest and detention, and rather than face humiliation and embarrassment from his associates, he decided to take his own life. In accepting the versions of the various police officers, the magistrate made serious errors of judgment. His decision was a product of a conspiracy by the security police to subvert justice. He failed to note that this was a big cover-up by police, or even if he did notice it, he justified their versions on dubious grounds. Among the glaring dubious summaries of the version, the magistrate, in justifying why it was not possible for Sergeant Achenbach and Warrant Officer Marais to have done hourly visits between 2200 hours and 1:30 a.m. on the 4th and 5th of February, the magistrate says the following in his, and I quote, Sergeant Achenbach and his colleagues were criticized for not visiting the cells regularly, and quite right so. But I find no reason to believe or think that more visits to the cells would have prevented the hanging. Close quotation. I find this conclusion astonishing, to say the least, and can only be attributed to the fact that the magistrate decided to accept the evidence of Constable Sihloho and that of Achenbach, the two who were in charge of the cells on the second floor during the 2 hours when no visits were done. Sihloho says he did not do visits on an hourly basis because the detainees were not troublesome. On the other hand, Achenbach says he did not do the visits between those times because everything was in order and that he was busy with other work. The magistrate, in summarizing this aspect, that Achenbach visited the cells at 12:45 and yet only discovered the body of Dr. Aggett at 1:30 a.m. On the other hand, Sihloho says it was only at 1:30 a.m. that Achenbach came to him to instruct him to open the gate leading to the cells so that he goes and does inspection. What I find further strange about these purported cell visits that night is that Constable Andre Martin, who was also on duty with Sihloho and Achenbach, made an entry of cell visits at 12:56. And then the magistrate noted that Achenbach only visited actual cell number 209 at 1:25 a.m. The entry of a cell visit at 12:45 was at the instance of Achenbach, who instructed Constable Martin to make that entry, which was in fact a false entry. The question to be asked is, why did Achenbach instruct Martin to make such an entry which was false? This, in my view, clearly indicates that Achenbach knew that something untoward was happening to Aggett, either that he was being carried back to his cell from interrogation and torture, or that some other unlawful act was being done to him in the cell. Keith Coleman, a Section 6 student detainee, told a 1982 inquest that a few days before his death, Dr. Aggett was unresponsive and seemed to be in deep thought. He also told the court that Neil had told him about an assault on him when his shirt was torn. This, he said, was done because his interrogators wanted to put more pressure on him and had taken away his privileges to an extent that he, Coleman, had to now and then give Aggett something to eat, like sweets and as well as cigarettes. Tawali Rumo, a detainee, told a 1982 inquest that when he saw Dr. Aggett in the second half of January 1982, he no longer looked happy. His manner of working had changed. He was working with some difficulty and did not look healthy and was no longer laughing easily. The day before his death, namely the 4th of February 1982, he saw Dr. Aggett in the company of Constable Chauke and another police officer. It was at about 3 p.m. Dr. Aggett was not walking normally, and tears were running down from his eyes and did not respond to greetings. Caesar Njikelan, a detainee, also testified that when he saw Dr. Aggett in January 1982, he appeared morose and very depressed. Earlier during the same month, he had met Dr. Aggett in the medicine room, and Aggett pointed to him a red mark on his right arm. Jabu Ngwenya also testified about the state of depression that he saw on Dr. Aggett while in detention during January 1982, and when he last saw him on the 3rd February, he could not walk properly. He walked white-legged. Dennis van Heerden, a detainee, also told the 1982 inquest that until early January 1982, Neil was in a fit mental, physical state, but later noticed that he was limping. Neil told him that he had been assaulted on the 10th floor and forced to do extraneous exercises whilst naked. In the morning of the 4th of February, Van Heerden noticed Neil in a very slumped over and listless position. He looked like a zombie. Neil walked with very little purpose. He dragged his feet and shuffled along. Later that evening, whilst asleep, Sergeant Achenbach did a cell visit to him and left. At some stage during the night, he could hear commotion in the passage outside his cell. He heard voices and footsteps. He also noticed people peering at him through the peephole of his cell door. His lights were still on. He had a feeling that the worst had happened. The next morning, he learned that Neil had committed suicide. He made a statement to Major Cronwright. He made a statement which Major Cronwright refused to accept, telling him that his men worked hard to protect South Africa from terrorists. The magistrate dismissed and disbelieved evidence of the witnesses who testified about the events of the 3rd and 4th February on flimsy, 3rd February 1982, on flimsy basis. For example, Keith Coleman testified about Neil's condition, and yet the magistrate concentrated on the issue of the torn shirt, as if that was the main issue, and failed to address Coleman's observation. Similarly, the witness Tabulirumo's evidence was dismissed without any factual basis, save to mention that he was uneasy in the witness stand. That may well be so, but it does not weaken his evidence, which was corroborated by that of Coleman and Orat van Heerden, to the effect that on the morning of the 4th of February, Neil walked with difficulty. The magistrate also treated the evidence of Sisan Jikelana in the same manner as that of Tabulirum. All that the magistrate concluded was that Sisan Jikelana was hesitant in his replies without being specific. This is despite evidence that he met Dr. Aggett, who looked morose, and that Aggett showed him a red mark on his hands. Mr. Jabungoya's evidence about the condition of Dr. Aggett was in the same breath dismissed on the basis that he was arrogant and selective about without being specific. This is despite his evidence being corroborated by Jikelana, Lirumo, and Coleman, specifically about his observation on the 3rd of February 1982. Sorry. The 2019 reopened inquest. This reopened inquest, as already indicated, started off in January 2020, and has been fraught with difficulties caused by the time delayed, during which time some of the witnesses who testified during 1982 had passed away, others have faint memories, and some documents could no longer be traced, including the docket. I've already set out the picture and layout of the detention cells and the 9th and 10th floor interrogation offices, which this court observed during the inspection in Loco in January 2020. An inspection of cell 209, in which the deceased Dr. Aggett was found hanging, demonstrates that access into it is through 2 doors, the outer door being a solid one with a peeping hole, and the inner door made of steel grille with a separate lock. Mr. Colin Savage, an architect, inspected the building plans of John Foster Square as it was during 1982. He testified that besides the access points already indicated herein, it would have been possible to gain access to the security cells on the 2nd floor through the female cells via a door that had by now been sealed up. When cell 209 was inspected on the 5th of February 1982, a number of items were found therein which should not have been there. Nyampula, one of the 1982 police witnesses who also testified in this reopened inquest, described it as a 5-star cell. Despite evidence to the contrary, the 1982 inquest accepted that Dr. Aggett was treated well based on the evidence of the security police. In this reopened hearing, this court has heard evidence by detainees who were in detention prior to and during Aggett's detention and after his death. There was also placed before me transcripts of several amnesty application hearings before the Truth and Reconciliation Commission by senior security police officers. This evidence in no uncertain terms proves, firstly, that detainees were subjected to torture, sleep deprivation, and assaults. Secondly, as Paul Erasmus, a former security branch officer, testified, it was a culture in the security branch to cover up evidence of ill treatment of detainees. Erasmus provided information regarding the activities of the security branch, in particular, manufacturing of evidence. He testified about the secret trip sanctioned by the head office during 1982, when he and Stephen Whitehead went to Somerset West at the house of Dr. Aggett's parents in search of evidence to prove that Dr. Aggett was suicidal and therefore took his own life. Erasmus gave evidence on the security police training courses. In his affidavit dated the 11th of February 2020, which was not challenged, it detailed the following, that the following were methods employed during interrogation of detainees, namely, 1, sleep deprivation, assault with a flat hand so as not to leave any mark, forced and strenuous exercise that would bring a detainee to a point of complete exhaustion so that he or she loses concentration, making a detainee strip naked, crunching in squatting position for a long time, including standing and balancing on a plank or bricks, electric shocks, strangulation, and suffocation using a wet bag. Erasmus told his court that the security branch officers were a law unto themselves. He indicated that they retained keys off-site, which they could use to enter the second floor cells and avoided second floor control office. They could gain access to the detainees in their cells without creating any paper trail. I do not in this judgment deem it necessary to repeat the evidence of each and every witness in detail, save insofar as it relates to the happenings and treatment meted to Dr. Aggett between the 24th of January 1982 to the 4th of February 1982, including the period referred to as the 62 hours of continuous interrogation and torture. It is common knowledge that in the 1982 inquest, the magistrate accepted evidence by the security police and in particular dismissed any notion that detainees, in particular Dr. Aggett, was tortured and assaulted. In his words, Dr. Aggett committed suicide because he had divulged information about his colleagues and that those disclosures brought about a feeling of uncertainty and discomfort to him. According to the magistrate court, Dr. Aggett felt that he had betrayed his friends and associates and was embarrassed to meet them and face rejection as an escape route. Dr. Aggett decided to end his life. Both Constables Nyampule and Maketa, whose duties amongst others included escorting detainees from their cells on the second floor to the 10th floor for interrogation, informed this court that they were aware of assaults and torture on detainees during 1981 and 1982, but were scared to tell the 1982 inquest about their observation. According to Nyampule, detainees would be kept for interrogation for long hours, and he would often find that the detainee had not been returned to their cells by 1600 hours when he knocked off, and would only be returned to their cells the following morning, having obtained keys after hours from the uniformed police stationed on the second floor. Constable Nyampule concluded that the absence of cell visit by the night duty staff comprising of Sihloho and Achenbach for a period of 3 hours in the late evening to the early morning of the 5th February was extraordinary and should have been subject of a disciplinary inquiry, which thing never happened. Both Nyampule and Paul Erasmus testified that it was irregular for McPherson to have permitted that Dr. Aggett keep the Kikoi cloth with him in his cell, as this was contraband. Once more, no disciplinary action was taken against McPherson. Maurice Smithers, a detainee, had testified and was cross-examined at length by Advocates Scarbott and DeFries during the 1982 inquest, when he detailed about what he observed on the 25th of January 1982, when Dr. Aggett was being assaulted and tortured in Office 1012. In opposing his version, the security police tendered a statement by Constable Maketa, who had on that day escorted Aggett to the 10th floor for interrogation. In this inquest, Constable Maketa told the court that when he testified in 1982, in this inquest, Constable Maketa told the court that what he testified to in 1982 was a lie fabricated for him by Major Cronwright. He testified that whilst he was waiting on the 10th floor to take Smithers to an optometrist, he saw Whitehead and 2 other police officers making Dr. Aggett exercise by jumping up and down, running on the spot, and being hit with what looked like a rolled-up newspaper. He now corroborated what Smithers said during 1982. Constable Maketa testified that he agreed to lie to the court in 1982 because he was intimidated by the security police and feared for his life. He confirmed that his statements before the first inquest were all false. 2 former detainees in the persons of Sizan Jikelana and Jabulani Ngoya testified not only about the assault and torture on them by various security police officers during the period December 81 to February 1982, including the observation of Dr. Aggett a few days before his death. They testified in 1982 as well as in this reopened inquest, They were cross-examined at length on why certain aspects of their evidence was not there in their testimony in the 1982 inquest. They responded that they were scared because of the presence of a number of their interrogators who sat in court, as they would have been subjected to harsher methods of interrogation or even be killed. Nicholas Dietlefs, one of Aggett's interrogators during the long weekend of 62 hours interrogation, told the court in the reopened inquest that there was pressure put on him and others by Major Cronwright not to disclose in the 1982 inquest evidence that Whitehead had left him with Aggett on the night of 30th of January 1982. Also that he should not tell the inquest that he had told him, Cronwright, that he was worried that Aggett would commit suicide. He considered that he was aware that some detainees were assaulted on the 10th floor, though he himself did not assault any detainee, including Dr. Aggett. He testified that whilst he lied in 1982 about certain aspects, he is now telling the truth, as there was no longer any pressure on him to protect fellow members of the security police. Dietlefs confirmed the culture of protecting fellow officers and stated that Major Cronwright stressed the fact that it was in the interest of the country that it be protected from communists and the African National Congress. He testified further that during the time when he was alone with Dr. Aggett on the night of the 30th of January 1982, Dr. Aggett disclosed to him about the involvement of Jan Theron in labor unrest and that this disclosure upset him. Joseph Petrus Woensdracht testified about his involvement with Dr. Aggett on the night of the 30th of January 1982 when Dietlefs and Whitehead interrogated Aggett. He, as in 1982, denied any ill treatment on Dr. Aggett and further said that he was not aware at that time that Aggett had been on interrogation non-stop since the 28th of January 1982. He testified further that Aggett wrote a 4-page statement that evening about involvement of Jan Theron in labor unrest but could not recall the exact contents thereof. What is strange is that it is that 4-page statement that was telexed to Security Branch Head Office in Pretoria the following day, which was meant to result in further arrest and detention. The security police refused to produce that 4-page statement in 1982 inquest, neither was it produced in this reopened inquest. The police claimed national security for their refusal to produce that 4-page statement and the telex. When Dietlef was asked what the 4-page statement contained, he replied as follows, I quote, I would lie, I would have to lie, if I have to tell you what was contained in those pages, close quotation. Similarly, Woensdracht responded at this reopened inquiry that he was not present when Aggett made a 4-page confession. He, however, said that he did have a look at the information contained therein, but cannot recall what it contained. He denied under cross-examination that the 4-page confession was a cover-up by the police to bolster their suicide theory. He persisted that the 4-page document had serious incriminating evidence against Aggett's friends. I am not persuaded that anything incriminating was in that 4-page document. I also have serious doubts that such a document ever existed. It was one of the cover-up incidents to distance the security police from the death of Aggett. Former detainees in the persons of Barbara Hogan, Reverend Frank Chikane, Jabu Ngwenya, Susan Jikelane, Ismail Moniat, Keith Coleman, Liz Floyd, all testified about the torture and assault at the hands of security police at John Foster Square during and after the death of Aggett. They corroborated each other in all material aspects and confirmed the methods of assault as detailed by Paulie Rasmus, a former security police officer. The late advocate George Bezos, in his affidavit, both in this reopened inquest as well as the reopened inquest of Ahmed Timol, pointed out that apartheid-era inquests tended to minimize evidence of ill treatment of detainees. He went on to say that improbable testimony of police witnesses was invariably rubber-stamped by inquest magistrates, especially of police versions that deceased detainees were treated with care and consideration. It is against this background that I now wish to deal with what happened to Dr. Aggett, which led to his death in the early hours of the 5th of February 1982. On the 4th of January 1982, Dr. Aggett was interrogated by Skalvik, Captain Odier, as well as Whitehead, all of them members of the security police. The interrogation took place from 10 in the morning until 1500 hours 15. Dr. Aggett, in his statement to Sergeant Blom, professor, said that Van Schalkwyk assaulted him in the presence of Whitehead by slapping him and also squeezing his testicles. This was vehemently denied by both Van Schalkwyk and Whitehead, and as already indicated, the magistrate accepted the version of the two police officers. On the same day, as well as on the 6th of January 1982, the Inspector of Detainees, Abraham Johannes Mouton, as well as Magistrate A.J. Wessels, were denied access to consult with Neil Aggett. McPherson lied to both officials by telling them that Dr. Aggett was out on investigation when he knew very well that he was present on the 10th floor where he was being interrogated and was assaulted. It was only on the 18th of January 1982 that Magistrate Wessels was able to consult with Dr. Aggett, who told him about the assault on him that had taken place on the 4th of January 1982. Aggett had an injury on his forearm that corroborated the event. This injury was also noted on the post-mortem report. Nothing was done about this complaint until the 4th of February 1982. On the 25th of January 1982, Maurice Smithers, a detainee, as well as one Constable Mohano Credence Maketa, noticed Aggett being assaulted by being struck with a rolled-up paper. Aggett was also forced to do strenuous exercises for many hours. The interrogation took place from 8 in the morning until 1500 hours in the afternoon. He was assaulted by Whitehead, De Brain, and Carr, all security branch officers. Once again, Magistrate Courts accepted the denials by the police officers and dismissed the evidence of Maurice Smithers on flimsy grounds by pointing out contradictions which were not material, for instance, that he had spelled his name differently on two separate statements. He also dismissed Smithers' evidence on the basis that Dr. Aggett did not mention the assault to Sergeant Blom on the 4th of February 1982. Also that Neil Aggett never told Orad van Heerden about these assaults. Magistrate Kotze made a fundamental error both in law and on fact when he disbelieved Smithers only to believe Constable Maketa, who has now in the reopened inquest said that he was instructed to lie to the 1982 court. Constable Maketa testified in the reopened inquest and said that it was a norm to deny any assault on detainees should such allegation be stated. The long weekend of interrogation of Dr. Aggett commenced on Thursday, the 28th of January 1982. This was after Dr. Aggett had penned a number of statements which Whitehead had simply torn because they did not contain the type of confession that he wanted Aggett to agree to. He, with the permission of his leader, Major Cronwright, decided to step up interrogation. They then devised a plan to keep Aggett awake for a long period, and in order to achieve that, Whitehead enlisted the services of other security officers to go on shift work, working in pairs day and night, questioning Dr. Aggett with the intention to break him so that he confesses to being an active member of the banned ANC and SACP. Whitehead, Carr, and De Brain interrogated Aggett from 8 a.m. until 1400 hours 48 on the 28th of January 1982. When they knocked off, they handed Aggett over to Johan Lucas at 1600 hours 18. Aggett was kept on the 10th floor until 6 a.m. on Friday, the 29th of January 1982, all the time being interrogated. When Lucas and Whitehead knocked off at 6 in the morning, they handed him over to De Brain, who kept him awake with questions and assault until 1600 hours on Friday, the 29th of January 1982. During this time, Aggett was given electric shocks. Sergeant Blom, to whom Aggett made a statement on the 4th of February 1982, confirmed that electric shocks constitute serious or grievous bodily harm. She also confirmed that Dr. Aggett told her that he had been electrically shocked. She also considered that it was necessary to have taken Dr. Aggett to see a doctor, but according to her, Dr. Aggett said he does not need any medical attention. When cross-examined by the late Advocate George Bezos, Blom gave a series of conflicting reasons why she did not deem it necessary to take Dr. Aggett to the doctor. The magistrate in the 1982 inquest did not deal with that anomalous situation in his findings. From 1600 hours on Friday, the 29th of January 1982, until 6 a.m. on Saturday, the 30th of January 1982, Dr. Aggett was continuously in the presence of Whitehead and De Brain, who applied electric shocks on him, and from 6 a.m. till 1800 hours on the 30th January, Dr. Aggett was in the presence of Captain Visser and Captain Swanepoel, who continued to interrogate him. When Visser and Swanepoel knocked off, they handed him over to Woensdracht, Dietlefs, and Whitehead, who kept him awake until the following morning of the 31st of January 1982 at 3 in the morning, when they took him to his cell on the second floor. Dr. Aggett, in his statement to Sergeant Blom on the 4th of February, complained about this long interrogation and lack of sleep. When she was cross-examined by Advocate Bizos during 1982 inquest, Blom downplayed and minimized the effect of such long interrogation. The magistrate court, in a strange finding on this aspect, said the following in his judgment, I quote, "At the instance of Lieutenant Whitehead and with the approval of Major Cronwright, Dr. Aggett was kept and interrogated on the 10th floor from the 28th of January 1982 until 3:30 a.m. on the 31st of January 1982. On the evidence before us, I cannot find without any reasonable doubt or on the preponderance of probabilities that this was not done with his consent and collaboration. I cannot find that he was deprived of sleep or ill treatment in any unlawful manner." The magistrate made this disgusting finding, notwithstanding the fact that Aggett, in his statement of the 4th February, complained about long interrogation and lack of sleep, during which he was slapped, electrocuted, and his scrotum squeezed. It therefore boggles my mind how Mr. Kotze came to the conclusion that Dr. Aggett agreed to all that. Sorry. Advocate Judge Bizos, in referring to the conduct of magistrates during that era, pointed out that the majority of apartheid-era magistrates had no real desire to reach the truth. They saw it their duty to protect organs of the state, such as the police. They, the magistrates, tended not to interrogate police versions vigorously and accepted ridiculous versions, like in this matter, that detainees preferred to commit suicide when the truth about them had been found. On the 4th of February 1982, Sergeant Blom Visser took a statement from Aggett at 9 in the morning, which statement she later handed over to her superiors and did nothing further because, according to her, the suspect, Lieutenant Whitehead, was her senior, and in terms of the rules, she, as a junior police officer, cannot investigate any case against her seniors. In my view, this is when all things started going wrong. Dr. Aggett was now left to the mercy of Whitehead, Cronwright, and others to decide how to discipline him. How dare he make such a serious complaint against a senior, ambitious security police branch officer? Sergeant Blom Visser, when testifying in the reopened inquest, used her marital surname of Visser. Her evidence regarding taking of the statement and how she went about was consistent to a large extent with what she told the court in the inquest. However, under cross-examination in the reopened inquest, she played ignorant about whether she knew that prior to the death of Aggett, other detainees, namely Wellington Chazibani, Elmon Malele, Matthews Mabelane, had died whilst in security police custody at John Foster Square. She said she did not know. I find that not possible to believe. She clearly was still playing the cover-up card. Dr. Aggett, in making a statement to Sergeant Blom Visser, related two incidents of assault. The first that took place on the 4th of January, 1982, when he pointed out Whitehead, Chauke, and Skalbeck as the culprits. The second incident took place over the long interrogation weekend when he was deprived of sleep and was assaulted by Whitehead, who had blindfolded him and electrocuted him. Aggett also showed her a scratch on his left radial nerve pulse. Aggett told her that despite him having complained to Warrant Officer McPherson did not make arrangement that he be seen by a doctor. In the 1982 inquest, Sergeant Blom Visser was cross-examined at length as to why she did not take Dr. Aggett to see the district surgeon. At first, she had told the court that she did not do it because the security police were still busy with interrogating Dr. Aggett. She later said it is because Dr. Aggett said he does not want to be taken to a doctor. Now, in the reopened inquest, while being led by Advocate Singh in evidence, she testified as follows. I quote, "Ms. Singh, you also told Major Cronwright that as they were busy with him, you were making arrangements or you made arrangements for him to be taken to the district surgeon. Am I correct?" Mrs. Fesser, that is correct. Ms. Singh, when did you make arrangements to take him to the district surgeon, madam? Ms. Fesser, when I went to excuse myself. Ms. Fesser, Ms. Singh, yeah. Ms. Fesser, no, just a second, no arrangements were made. No arrangements were made. Sorry, I'm withdrawing what I said with Aggett investigation. My hands were tied. I could not do anything further. Ms. Singh, when I asked you earlier as to whether you had arranged medical attention before you changed your mind, you said yes. You went to Major Cronwright and you spoke to him and told him that arrangements had been made for him to be taken to the doctor. Where did you get that from? Answer, it is long. Usually that is what happened. It ended there. Mrs. Blomfesser clearly contradicted herself on a very material aspect of this case. She hid behind the issue of seniority and later shifted the blame of not having taken Dr. Aggett to the district surgeon to a commander, and later said it is a duty of the security police to see to it that detainees be taken to a doctor. Mrs. Blomfester was clearly still on the trajectory to protect Whitehead and Cronwright, even at this late stage when it is known that both have passed away. If she now says that she had told Cronwright and her own superiors that Aggett needs medical attention, why did Cronwright and Whitehead in the evidence in 1982 say there was nothing wrong with Dr. Aggett and that he was in good spirits? In the late hours of the night of the 4th of February into the early hours of 5th February, 3 detainees, namely Susan Jikelana, Keith Coleman, and Jabu Ngwenya, had commotion and observed unusual activity in the corridor of the second floor. In particular, Keith Coleman saw 4 figures hurrying past, and thereafter all the cell windows were banged closed one by one, and the main gate to the cell block was slammed and locked. Of great importance is what Susan Jikelana told the court, namely, that he heard the main gate being opened and several low voices, and when he heard that, he stood on top of the toilet seat and looked out into the passage, where he saw approximately 6 persons carrying Aggett in the direction of the lifts. He says they carried Dr. Aggett in the way Muslims carry their dead at funerals, and they were moving quickly. Jabu Ngwenya saw police officers who stood in front of each cell door, observing the peephole into the cell corridor. This incident described by the 3 detainees is of crucial importance. The incident must have taken place during the period when no cell visits were recorded by the night duty staff. It is a period between 2200 hours and 1:30 a.m. It is at that time that something was done to Dr. Aggett which led to his death. The question that remains is, who were those people seen by the 3 detainees in the corridor? Susan Jikelana was adamant that when he stood peering into the corridor, he saw Dr. Aggett being carried shoulder high. The people carrying him were moving from the lift towards the showers. Under cross-examination by Advocate Coutier, Susan Jikelana maintained that he did not tell the 1982 court about that incident because he was scared that his interrogators, who were in court at the time, all the time, would have later subjected him to further torture or even kill him. Mr. Jikelana informed the court that when he consulted with his attorney, Mr. David Dyson, he did relate to him that version. When pressed further by Advocate Coutier on that issue, Susan Jikelana expanded in response as follows. But I'm trying, I quote, "But I'm trying to also illustrate the state of mind I was in, and I never saw myself as just an individual. I was part of a whole. Maybe if my Lord can be allowed to, even David Dyson himself from time to time was quite harsh with me, saying that I was not forthcoming when I was testifying. I cannot remember whether I did respond to him or whether I just spoke internally, because to me, I just could feel for him when he was saying that, because in his view, I must say as much as I can, and in my view, I'm measuring what I can say because I do not know what will happen to me, and my conclusion or my view is that the greatest of probabilities is that whatever I say determines my future relations with the special branch, and I knew that even in future, I was still going to interact with these people, whether through a bullet in my head down the line or whether through detention inside with more tortures in whatever form." Close quotation. It must be recalled that Mr. Jikelana had been in and out of detention even before the detention of Dr. Aggett. His second arrest took place when he was at the Aggett's residence in Johannesburg. So for all intents and purposes, he knew a lot about the activities of Dr. Aggett. In my view, to protect himself and with the type of fear that he had for the police, he, in my view, he, in his view, was justified to withhold that crucial information. Keith Coleman, who was detained in a cell facing the long corridor, heard a commotion in the early hours of 5th February. He ran to the window of his cell and saw figures going past. A moment later, all windows were closed. He could not make out who were the officers walking past. He was released from detention on the 26th of March 1982 and immediately placed under banning order. Later, he was to be called as a state witness in the case against Barbara Hogan and Cedric Mason. Mr. Coleman did not say much, save to say that the people moved from the main gate leading into the second floor cells inwards to the rest of the cell. When he heard this commotion, he was in cell B3, which is close to the main gate. Jabu Gabriel Ngwenya also testified in both inquests. He saw Dr. Aggett being assaulted on the 10th floor on the 25th of January 1982 by Whitehead and others. This information he did not tell the 1982 inquest, and when asked the reason why, his response was that he was scared because the security police had in the past killed people, and as for him, one day they picked him up and one of them stabbed him and they left him for dead. He felt vulnerable even though he had been released at the time when he testified in 1982. Ngwenya further testified about his chance meeting with Dr. Aggett on the 3rd of February 1982 in the room where they keep clothing. And Dr. Aggett told him that he had been badly tortured and also showed him a wound on his forehead. He concluded his evidence with what he saw in the early hours of 5th February 1982, when he heard a commotion in the corridor. He peeped through the window and saw a number of white police officers moving about. They closed the windows and blocked the peepholes. Mr. Ngwenya found that to be strange. This evidence, although not presented during the 1982 inquest, corroborated that of Keith Coleman to a large extent. The possibility is that the commotion they heard or witnessed could have been at the time the security police were rushing to Dr. Aggett's cell after he had been found hanging. This only leaves evidence of Susan Jikelani, who is the only one who says he saw Dr. Aggett being carried shoulder high in the corridor. Shortly after Sergeant Blom had taken the statement from Dr. Aggett, she not only informed Major Crowright about who the suspects were, she handed the docket to her senior, Juan Ferreira. It is common knowledge that Whitehead got to know about the accusation leveled against him, and this angered him, and 15 hours later, Aggett was dead. Whitehead, Carr, and Warrant Officer DeBrain confronted Dr. Aggett, and Whitehead said to Aggett, I quote, "Is this the way you treat us now after we had been so good to you?" Close quotation. This remark by Whitehead cannot and should not have been viewed in isolation in the 1982 inquest. It came against the background of Neil Aggett having been kept awake for 62 hours, and each day Whitehead told Neil that he has not as yet told the truth. Whitehead's affidavit filed in the 1982 inquest reads like a well-rehearsed cover-up story, parts of which reads as follows, I quote in Afrikaans. Neil says 100 uur het ek weer van diens gegaan. Dit was op die 30ste van Januarie 1981. Dieselfde dag 1800 uur het ek weer diens rapporteer. Ek het toe weer eens gemerk dat daar nog 'n paar leemtes in sy verklaring is wat Dr. Aggett moes opklaar. Ek het hom toe weer in verband met die leemtes ondervra. Close quotation. That rewriting of one statement went on for 3 days, for the next 3 days. It is therefore inconceivable that the interrogation rewriting could have been taking place in a manner described by Whitehead as being peaceful and orderly. He was lying. In his affidavit filed in the 1982 inquest, Whitehead said the following after Dr. Aggett had rewritten the statement over and over again. Again, I quote his Afrikaans version. Ons het tot die gevolgtrekking gekom dat Dr. Aggett ons nie die volle besonderhede van sy bedrywighede en die betrokke organisasies verskaf het, dat hy sekere inligting waaroor ons beskik het van ons weerhou. As gevolg hiervan het ons besluit dat Dr. Aggett nou meer intensief ondervra moes word, en om die continuïteit van die ondervraging te behou het ek nie nodig gesien om hom terug na die celle te neem, en ook omdat daar behoorlijke faciliteiten in die kantoor vir hom beskikbaar was om behoorlijk te kan rus. This statement marked the start of the 62 hours of non-stop interrogation by various officers. He was assaulted, tortured simply because he did not confess to being a member of any banned organization. Dr. Aggett was taken back to his cell at 3:30 a.m. on the 4th of February. The police claimed that the 62-hour interrogation session with Aggett was a success because, according to him, Aggett had confessed and implicated a number of his comrades. The police who were ultimately believed by magistrate courts, argued that it is those disclosures that led Dr. Aggett to Dr. Aggett committing suicide that evening. This is despite the fact that no evidence besides what Detlefs and Whitehead had told the court was produced to prove the comrades' betrayal story. The strange thing about that betrayal story is that no one alleged to have been named by Aggett was ever arrested. Once more, Whitehead and Detlefs lied in order to cover up the assault and torture of Dr. Aggett during the 62 hours of interrogation. The late Advocate Bezos, writing in his book, No One to Blame, at page 118, said the following about Whitehead. By the time Aggett had written and indexed a statement 65 pages long, the police were not satisfied. Aggett had added 28 more pages. These two, it turned out, were insufficient for Aggett's ambitious young interrogator. Lieutenant Whitehead had been with the security police for about 6 years. He was a determined man when he assumed command of Aggett's interrogation on Monday, 25 January 1982, the day he heard of Aggett's complaint to the magistrate, and the same day that Smithers saw Aggett assaulted on the 10th floor. The suspect, whom Whitehead had been watching for 3 years, was finally within his grasp. Here at last was a chance to prove that Aggett was involved in the illegal activities he had long suspected. Close quotation. Constables Paul Setlo, Andre Martin, Stephen Esling, and Sergeant Achenbach, as well as Warrant Officer Marais, were the police officers on duty the night that Aggett was found dead in his cell. The standing operation and procedure is that cells be visited every 1 hour. However, this did not happen on the night of the 4th February, between 22 hours and 1:30. This was a serious transgression which was never followed up by any disciplinary hearing. There were contradictions in the evidence Setlo and that of Achenbach as to what Aggett did when they inspected his cell at 2200 hours. One said Dr. Aggett made a thumbs up, whilst the other said, Aggett spoke and said he was fine. There is also the unexplained entry by Enslin of a visit having been done at 12:30 by Achenbach, when in fact no visit was done. Magistrate Kotze, in his analysis of the evidence of the above-mentioned police officers, concluded that the evidence about the fact that nobody from outside, including members of the security branch, had no access that night to the cells was not contradicted or disputed. He said that he could not find inherent improbabilities that reflect adversely to the evidence. He accepted the evidence as reliable. This finding leaves much to be desired and proved beyond doubt that Kotze was not prepared to subject anomalies in that evidence to much scrutiny. We have now heard in this reopened inquest that security branch officers had access to the cells and to the detainees at any time they wished. The fact that Aggett was returned to his cell at 3:30 a.m. on the 31st of January 1982 proves that. Joseph Nyampule, as a retired police officer who worked on the 2nd and 3rd floors during that period, testified in the reopened inquest that uniform branch had their own set of keys, so did the security branch. These were kept by Major Cronwright. He further testified that access to the 2nd floor was also possible through the charge office. He also emphasized that there was a way to access the 2nd floor without going through the front charge office. The detainees, Frank Chikane, Prema Naidu, Barbara Hogan, including Nyampule, the police officer, all testified that belts, shoelaces, scarves were not allowed in detainees' cells because these were items that could be used by detainees to harm themselves. The question that was not answered in 1982 inquest is, how come all the banned items found their way into Aggett's cell? Was it not a way to encourage him to commit suicide? When Achenbach and Marais last visited his cell at 2200 hours, they must have been aware of the contraband and yet did nothing to remove same. Orat van Heerden had expressed a fear, so did Detlefs, who decided to keep quiet about the possibility of Aggett committing suicide. It must also be recalled that 2 days earlier during that long weekend interrogation, one of the police officers said that he does not think that Dr. Aggett will hold on for any longer. Detlef, testifying in the reopened inquest, said that after Aggett had told him about Jan Theron being the leader of the underground movement, he foresaw the risk that Aggett may take his own life. It must be mentioned that he did not say so in the 1982 inquest. He added that he did not mention it because they were threatened. He told the reopened inquest that Major Cronwright and Lieutenant Whitehead threatened him not to tell the truth. It was an instruction from Major Cronwright that members of the security branch needed to stay together and not split, clearly indicating covering up for each other and support each other at all costs. Major Cronwright told them they are all there for one purpose, being to fight communism. Detlef also considered under cross-examination by Advocate Vani that he committed a crime by not reporting assault on detainees and thus covered up crimes committed. Covering up was routine practice within the security branch. Detlef, whilst admitting that electric shocks as a form of torture was used on detainees on the 10th floor, found it difficult under cross-examination to tell the court how did he know about that and who in particular applied electric shocks on the detainees. He kept on saying that it was a general thing and commonly and spoken about in the corridors. I have no doubt that Detlef, in responding to this question, was trying his best to distance himself from electric shock or torture treatment. On the other hand, he was covering up for Whitehead and Cronwright. And on the other hand, he projected himself as a smart interrogator who never used any form of assault or torture on detainees. I have no hesitation to say that he was clearly lying. He not only knew about this, he observed it and probably also used electric shocks whilst interrogating detainees. Finally, under cross-examination, Detlef considered that at some stage he did use force during interrogation, and he stopped as he noticed that it was not yielding any positive results. He used to slap detainees across the face. He admitted that he also used physical assault on Barbara Hogan. Detlef, who had been left alone with Dr. Aggett during the night of the 30th of January, told the court in 1982 and in the reopened inquest that Dr. Aggett mentioned Jan Theron, Oscar Mpeta, Orant van Heerden, and others as members of SACTU, and that they were involved in organizing workers to sabotage the economy of the country. When it was put to him that SACTU was not a banned organization, and also that, in fact, no action was taken by the police against the people Aggett named, Detlef gives a nonsensical answer, namely that there are different units in the police force. The statement that Detlef called the breakthrough statement was nothing and incriminated no one. In fact, it never existed. When Detlef told Whitehead and Cronwright about his fears that Aggett may commit suicide, he says that Whitehead kept quiet and he attributed this to the fact that Whitehead was inexperienced. Major Cronwright had understood him and did not tell him if he would take any steps. He left it there because Cronwright is his senior. He formed the opinion that both Whitehead and Cronwright did not take that statement seriously. He, however, considered that both Cronwright and Whitehead were under a legal duty to protect the well-being and lives of detainees. The question that remains to be answered is whether Detlef, having admitted that he lied during the 1982 inquest, makes him an accessory after the fact in respect of the direct deeds and omission by Cronwright and Whitehead, which led to the death of Aggett. What is of further importance is that Detlef's head, Dr. Aggett, says he does not wish to live any longer and that he cannot forgive himself. This, according to Detlef, Aggett said at the time that Whitehead was in the process of sending the 4-page statement to head office, and yet nothing was done. When it was put to Detlef that the whole issue about the 4-page telex was a fabrication and that it was put as a story to back up the police version as an explanation for suicide, Detlef vehemently disputed this and stood by his word that it did happen. If it is true that Detlef says that Aggett had incriminated people like Jan Theron and others, and he was aware that Aggett had threatened suicide, then they as the police should have had an interest in seeing to it that Aggett lives to give evidence against people he had incriminated. The fact that all of them said nothing about Aggett having said he does not wish to live anymore proves that it did not happen that way. Aggett never contemplated suicide. What makes it further improbable is if he did say it, why then go all the way to his high school and break into his parents' home in Somerset West in search of evidence to back up their ridiculous version that Aggett committed suicide? The story of suicide becomes more ridiculous and a joke when Detlef testified that he heard in the corridors of John Foster Square that Dr. Aggett hanged himself with a tablecloth that his family had brought for him to have lunch on. We all know that no tablecloth was used in the hanging. In any case, tablecloths would never have been allowed inside the detainee's cell. However, what is of importance is to note that in the final analysis, Detlef considered and admitted the following. One, that he slapped Barbara Hogan and made her sit under a table whilst being interrogated. Two, that he insulted and verbally abused Reverend Frank Chikane by calling him a kafir predicant. Three, that it was routine for members of the security branch as a whole, which included fabricating of evidence and lying under oath. Four, that he, Detlef, was forced by his seniors to lie and cover up in the case of Dr. Aggett. When cross-examined by Advocate Mlocho, he agreed that he lied under oath when testifying in the case of assault against him by Barbara Hogan. Despite that, the magistrate believed him and acquitted him. He told his court he did so in order to protect his senior, amongst them Lieutenant Whitehead. His exact words were the following. I quote in Afrikaans, "Ek was deur my senior officiere by die veiligheidsdak daartoe gedwing en ek het nie ander keuse gehad nie, alhoewel dit teen my gegeen is om sulke leuns te vertel. Ek was aangesê om vas te getuig ten einde die ander lede van die veiligheidsdak, soos onder andere spesifiek Lieutenant Woensdrag, asook Lieutenant Whitehead te beskerm." Close quotation. Detlef considered further that as far as he could recall during his time, no security branch officer was ever convicted of having assaulted a detainee. There was a lot at stake for the security police in respect of the Aggett inquest. Hence, a lot of preparation was done for the inquest itself, which included the trip by Paul Erasmus and Lieutenant Whitehead to Somerset East. The police backed the offices of George Bezos and they rehearsed evidence. When it was put to him that a tie and 5 pairs of socks were found in Dr. Aggett's cell after his death, and also that police did not do cell visits between 2200 hours and 1:30 on the 4th to 5th of February, Detlef said that the police were negligent. He agreed that the responsible police officer should have been charged for neglect of duty by the department.
Very elaborate judgment there in the Dr. Neil Aggett inquest. We're going to take you back in a moment, but now to this. Some South African students who were caught in the crossfire in Ukraine landed this morning at the OR Tambo International Airport. This as the Russia-Ukraine conflict
completely sealed and had no windows. Detlef confirmed that Stanza Bopape was electrocuted and died on the 10th floor of John Foster Square, and thereafter the police took his body to Mpumalanga, where the body was blown up and thrown in a river full of crocodiles. He confirmed that the security police, as usual, covered up for each other and lied to the public that Stanza Bopape escaped en route to Vereeniging and was never seen again. It is on record Lambert testified as written. Warrant Officer Lambert, testifying the reopened inquest, told this court that when he arrived on the second floor, there were a number of police officers in and around the cell and corridors. He took 4 photos of Dr. Aggett while hanging on the grill and did not take any photos after the body had been brought down. He says he did not do it because the pathologist was already there and it is them who take such photos. He cannot remember if the light was on or off when he took photos and later looked for fingerprints. He had a torch and a lamp, which he uses when doing crime scenes at night. He says visibility was good, even though he cannot remember if the lights in cell 209 were on or not. When he took the photos, Captain Victor, the investigating officer, pointed out to him what photos to take. It was pointed out to Lambert that in the 1982 inquest, the 4 photos were not handed in. He could not explain why and said he handed up the photos to the investigating officer. Lambert testified, as he did in 1982, that only one identifiable fingerprint was uplifted on the grill. He explained how he went about processing the bar by using an aluminum powder and a fingerprint brush. He dusted the whole area around where the deceased was hanging. He first dusted the back of the grill whilst the body was still hanging, and after it was taken down, he did the front portion. He elaborated that he found fingerprints, not one fingerprint on the bars, and out of all fingerprints found, only one identifiable one, being that of Dr. Aggett, was found. When asked what happened to other fingerprints, Lambert responded by saying that there were in fact not fingerprints, but just marks on the bar itself. The identifiable fingerprints was found directly above the knot of the material on the bar. When Mr. Lambert was asked a pertinent question as to how he managed to reach the top of the grill in order to locate the identified fingerprint, his answer was, in my view, amazing. He says the following, I quote, Lambert, my Lord, believe or not, I do not recall. I do not know if they brought a ladder for me or whether I climbed there myself. I'm honest, I do not remember. Ms. Singh, but you would agree that you would have had to use some method to get up. Lambert, that is correct, my Lord. What is critical and what was not analyzed by Magistrates Court in 1982 inquest is the following. Why is it that only one fingerprint was found on the back of the vertical bar linking to Dr. Aggett? What happened to the foreline which indicated that other fingerprints were uplifted, though not identifiable? How did Warrant Officer Lambert manage to climb unassisted to the topmost bar and take a picture there? Constable Thabo Mutupe, testifying the reopened inquest in relation to fingerprints taken in the cell and surfaces of the steel bar, said that if he had attended the scene in 1982, he would have lifted more fingerprints by using various techniques available at the time. Mutupe's evidence on this aspect was corroborated by Mr. Zitze Alberte, a fingerprint expert, who said that he would have expected that there be more fingerprints available on the steel bars if Dr. Aggett climbed up the grill to attach the scarf and then hang himself. Frank Dutton, a police specialist investigator with 38 years of experience in the police service, also testified that the crime scene investigation into the death of Aggett was done in such a way as to cover up real events. Mr. Dutton had serious complaints regarding the manner in which the forensic investigation of cell 209 was carried out. He was particularly skeptical about the lack of proper photographs, fingerprints, and the fact that Captain Struve, colleague of Lieutenant Whitehead, removed the body of Aggett from the grill. The only photographs of Aggett's body in the reopened inquest were obtained from the SAB documentary and sourced by the law firm Weber Wenzel, the attorneys for the Aggett family. Photos showing his body hanging as well as after it had been placed on the floor are missing. There are suspicions that they were intentionally removed and destroyed by those who persist with the cover-up. Dr. Stephen Naidu, an independent forensic pathologist who was briefed by the Aggett family in the reopened inquest to study records of the original inquest and to provide specialist forensic pathology opinion on the cause, mechanism, and nature of the death of Dr. Aggett, noted the following shortcomings. Firstly, he noted that the state pathologist failed to attend the scene of death contrary to the provisions of Section 3.4 of the Manual of the Performance of Postmortem. Dr. Naidu opines that had the state pathologist attended the scene, there would have been a more accurate time of death rather than estimation done by the police. Also that he would have been able to give a more precise nature of the ligature and intricacies of its knot as it was found around the neck. And lastly, the state pathologist would have been able to give an on-site assessment on the capability of the deceased to mount onto the bus to suspend himself successfully. Secondly, Dr. Naidu expressed concern that autopsy examination was hurried up and conducted within 7 hours, and that the family had not been given adequate information about the circumstances of the death, so as to enable them to make timeous arrangements to appoint their own pathologist. That is why Dr. Botha, the family pathologist, arrived late when Dr. Kemp had already commenced with the autopsy examination. Dr. Botha was prejudiced and placed at some discomfort of having to contend with an already opened body. He could not have had an opportunity to examine the ligature as it appeared around Aggett's neck. Dr. Naidu also questioned the failure of the post-mortem report examination to include comprehensive and wide subcutaneous skin flap dissection under the skin of the trunk and limbs to look for concealed bruising. This would, according to him, been helpful in view of the history of torture and assault on Dr. Aggett. Dr. Kemp, in his testimony, had mentioned a triangular injury described as a fresh bruise over Dr. Aggett's upper right scapula. Dr. Naidu regards this injury as unlikely to have been caused or resulted from Dr. Aggett convulsing whilst hanging or pinching his skin against the bars. He is of the view that this fresh bruise was an ante-mortem injury from blunt force impact such as a fall or an assault at some time before the suspension. Ismail Mamoniat, one of the detainees, saw Dr. Aggett on the 3rd of February, and they were both on the first floor to be signed out. He noted that Aggett appeared to be in a terrible and dazed state. Aggett did not respond to his greetings on that day. The condition that he saw Aggett in made him doubt that Aggett had the physical capacity and strength to commit suicide in the manner described by the police. Firoz Kachalia, a detainee at the same time as Aggett, saw him a day before his death, being the 4th of February. He says that Aggett looked like he was at breaking point. He could not speak to him as there was about 6 police officers in the church office. Mr. Ronald Castles, a veteran of the ANC SAP movement, testified about a document titled Inkululeko Freedom, February 1972, which he and the late Joe Slovo authored. He disputed that the original document had instructions that SACP members should rather commit suicide than to betray the organization. This was a document that the magistrate De Villiers relied heavily on in the Timor inquest in 1982. Mr. Castles indicated that suicide was never a policy of the SACP. The evidence of Thabo Mutupi as well as that of Alberts, analyzed together, demonstrate Aggett would not have been able to climb up the grill on his own unassisted. Thabo Mutupi is a fingerprint technician stationed at the Johannesburg Central Police Station. Mr. Alberts is also a fingerprint expert. Besides the observation of the poor quality of the photographs, both of them simulated the climb up the grill where Aggett was found hanging. Under cross-examination, it was put to Mutupi that only the left forefinger of Aggett was found on the grill. He responded that Aggett would have gripped the bar with his whole hand, leaving prints of his palm, thumb, and fingers. Mr. Alberts performed a simulation in cell B18 on the 2nd floor. He asked a colleague to climb the bars to see where he would touch and how he would climb up the search bars, and he took photos. That exercise left various fingerprints on the bars. His colleague made 5 points of contact with the bars when climbing the grill. A second simulation after the bars had been cleaned also produced the same results, which enabled him to lift five developed set of fingerprints that were clearer than when the bars were dusted. Commenting on the evidence of Charles Wynand Lambert, who only found 1 fingerprint on the grill above the knot on the back of the bar, Ms. Alberts indicated that one would have expected to find a sequence of fingerprints which would include at least the fingerprint, the middle finger, and possibly the ring finger, pinky, when lifting those prints. The taking and uplifting of the single fingerprint by Lambert is, in my view, undermined by inherent improbabilities attached thereto. Alberts used a stepladder to get to the top of the grill and had both his hands free to take pictures. On the other hand, Mr. Lambert now says He could not recall if he used a stepladder to carry out his work on the grill. If Mr. Lambrecht struggled to get up to the top, how then did he manage to take a picture that only produced one identifiable fingerprint? Lambrecht confirmed that when he climbed up the grill, he was wearing latex gloves and said he had dusted those sections which would have been disturbed by his touching and pressure before ascending. He confirmed that he was not challenged by dust when attempting to lift the prints. He considered that in 1982 he did not say anything about dust on the grills. Cross-examined by Advocate Vani, Mr. Lambrecht considered that if the Follin was available, it would have depicted a number of prints and not one. This evidence he did not tell the 1982 inquest. No one could say what happened to the Follin. Mr. Lambrecht's answers were as follows. Mr. Lambrecht, my lord, I can only comment on it that would the Follin have been available in the court, we could all see how it was made and the fingerprints in relation to one another that might be on the Follin, but it would not have only been one visible print. Mr. Van made the comment. You see, the problem we have, Mr. Lambrecht, is there is literally a great deal of suspicion about what happened to Dr. Aggett, and everybody wants to put their minds at rest as to what actually happened. And one has already heard questions put to you by Advocate Singh for the state that there might have been other ways of getting the print there, and if there had been a reference in the first inquest proceedings to evidence to show that it was not a solitary identifiable print, but at least a series of prints, even if the prints were not necessarily that good, that would have helped the first court and certainly this court to come to a more definite finding on the matter. Mr. Lambrecht answered, that is why I am referring to the importance of the Follin, which unfortunately is not available. That would have shown it, because I would never just take a small piece of Follin and lift one print. I also cannot recall what was on the Follin. The evidence by Frank Dutton, who had been appointed to also investigate cases arising out of the findings of the TRC, was also the first chief investigator of the Directorate of Special Operations, also known as the Scorpions, summarized the cover-up relating to the death of Aggett and many other detainees. Mr. Dutton testified about his interaction with Eddie Chauke, a former security officer, on the 4th of November 2015. Chauke was part of Aggett's interrogation and was present at the last interrogation on the 4th of February 1982. Chauke told Dutton that Whitehead had been angry with Aggett for opening an assault case against him, and that in a rage, Whitehead tore up Aggett's written statement. Whitehead exclaimed that it was all lies and that they will get the truth out of Aggett. Chauke told him that it was the intention of Whitehead to resume the interrogation later that night. Dutton concluded that the version put up by the security branch before the first inquest amounted to fabrication and a cover-up to conceal the abuse and torture of Aggett and the conduct of the security branch police in relation to his death. Captain Martin Johan Nodier, who had been called up from East London to assist in the interrogation at John Foster Square, had concluded in January 1982 that Aggett should be released because, according to him, there was nothing linking him to the so-called big treason soup. Nodier admitted that Aggett had made it clear to him that he was not a supporter of the ANC. In conclusion, Dutton considered that it had now been proved that security police covered up crimes and where necessary, they misled courts by fabricating evidence. Joseph Petrus Woensdracht was also involved in the interrogation of Dr. Aggett on the night of the 10th of January. He, Detlefs, and Whitehead worked together that evening. Woensdracht disputed Detlefs' evidence that he and Whitehead left him alone for a period of 5 hours with Aggett. In fact, his whole evidence during 1982 and now is a denial or knowledge of any assault or torture on any detainee. This is despite wide evidence already given at TRC and in this inquest. He, in most instances, when confronted with real evidence, refused to respond and claimed the right not to incriminate himself. It was put to Woensdracht that his statement that he was surprised why Aggett had complained to Sergeant Blom, since, according to him, Aggett was happy to spend the night in the 10th floor interrogation office than to go to his cell, was a fabrication and a continuation of cover-up that he conducted in 1982. It was put to Woensdrag that he misled the 1982 inquest and that he is continuing to do so in this inquest. His response was that he will not break his response was that he will not break the oath he took. He told the court that when he joined the security branch, he took an oath of secrecy not to disclose matters relating to certain issues about the security branch. And to date hereof, he still considers himself bound to that secrecy. That statement clearly indicates that Woensdrag still owes allegiance to the now disbanded and disgraced security branch police. He does so despite overwhelming evidence of cover-up, murder, deceit, and torture, which was placed before the Truth and Reconciliation Commission by his seniors. He is unrepentant. It is also interesting to note that him and Detlefs were also involved in the interrogation of Ernest Dipale, who also died by hanging in his cell at John Foster Square in August 1982, a mere 6 months after the death of Dr. Aggett. Woensdrag would not tell the court what the contents of the so-called 4-page statement made by Aggett entailed. Safe to say that Aggett incriminated his colleagues. Woensdrag, like Detlefs and one Visser, also all claimed not to know that Aggett had been kept awake since 28 January 1982. Nicholas Johannes Visser and Captain
and they went into town and burned down the market, right? So
First testified he was not testified about Aggett, and also that he did not have any knowledge about it. Any knowledge claimed that Aggett was claimed that Aggett was and that atmosphere was friendly, and that atmosphere was friendly. All that he said that he made a report when he made a report at the end of his shift that Aggett wants to talk the truth. He himself did not get from Aggett what that truth. He also strangely does not also call the names, not alcohol and names, he not actually disclosed to him and so on. It is clear to this court that this talking of the taking was nothing else but a build and foundation that Aggett and Woensdrag worked on 6 a.m. from 6 a.m. to 3:30 a.m. January 1982. First, was claiming no Aggett have known that Aggett for approximately 54 hours prior to him, taking all this court that he would not have his approach to interrogate, the questions and answers when responding. So, Mr. Professor, if I am hearing you, even if you had known that we had approximately you would have done everything that they have continued to use abusive treatment, would have kept him away for another words, continue to torture him by way of sleep deprivation. Mr. Professor, also going to talk to Savani, because this was your instruction, regardless of any knowledge of sleep deprivation, since you were instructed to give on separate hours on for you would have simply done that. That is what I said. Mr. Professor is correct. Instructions were him out. Professor was carrying out the Millennium Rise and the Millennium Rise and intensified question. It is therefore not surprising that the bluntly invited it was a continuation that resulted in the 4-page incriminating statement. Rule of Jacoba's Fender was also a member of the First Press, although he did not interpret. He in his understanding before the CLC in respect of his in the Barbara Hogan interrogation that he interrogated detainees. When he interrogated detainees, he applied from many pressure on them. Interrogation for long hours during the day, not always during the prolonged standing, tearing up statements, running up sit-ups, and Inspector also told us that he claimed that they had been torturing a detainee, usually no marks visible. He agreed with the statement and evidence, but there was no space, to accuse other members of irregularities. They had to stand together and cover each other in order to prevent the security. He accused former nation party of the PW both of abandoned the security. Praised General for having stood up for the security branch. Advocate Bani put affidavit detainees, namely Omonian, which they accused him of obstruction. Fenter denied allegation. When it was put to him that he applied for amnesty in respect of the result really harm committed on Reagan Shopping. Fenter responded that he did so on advice of his. He gave the same answer in respect of his assaulting Barbara Hall. Mr. Fenter is clearly not telling the truth about what happened in detention while against others. I cannot explain why he applied for it. He has not played open cards and his evidence as false and misleading. He is still in the intention to cover. Fenter's partner in the interrogation, a certain Daniel Ilabras. He's a young officer in the police and went on security course focused on banned organizations. Daniel as a member of the Nicholas Commander interrogating males and they handed it over to Whitehead, Swanepoel and Festus played the interrogation in the interrogation. They said Neil was showed signs of. They denied being aware that our nation has been kept our January 1998. They presented to this court evidence that though they heard that other interrogators and assaulted they themselves did not. In particular, denied having the image Malomonian, but admitted that they had a major that for long period. This last concession is corroborated by former police Polly Rasmus and Frank Dutton. Gideon Maketa also testified that his detainee or made to stand for 3 days after which he had stolen legs as elephant legs. Swanepoel and Festus interrogated Neil about his union and possible involvement in any of the two and General. Swanepoel said that apart from informers documents which he had not dated to this day, Neil told he now wanted to tell it. There was no time that as the 1800. He claimed all along that Neil was physically and mentally was a lie. Later in his evidence, Swanepoel obtained that he made on statement and further considered the statement that he obtained never made freely. He agreed that in 1918 never committed this act, and yet in this inquest he still maintains that the 1982 evidence was correct, as there was no physical. This is clear act of still covering up. Under cross-examination by Aggett maintained that he had no regrets about his because according to him, he had them strictly within the law. He further disingenuously denied that he was cover in the security police. He claimed that if he had ever come to his knowledge, committed crime during interrogation, he would have reported it. This he said despite the members of the party do everything by their ability to protect the country against terrorism and the he however persisted that there was no cover of death of the death of the police complicated allegedly penned by members to committee. Swanepoel admitted was a cruel and intelligent form of interrogation, and accepted that the mining physical and health of detainees, taking them and listening their questions. The final analysis that and that in effect, and that all he wanted was a powerful by Neil confession which he implicates himself. He agreed that eventually the so-called sensitive information allegedly given by Neil amounted to nothing. Professor as a senior knowledge of legal probation and illegal probation and illegal himself. The last hours of Neil's who after taking down a statement morning of the 4th in which Neil implicated Whitehead in assault conviction went ahead suspect Whitehead. It is therefore not surprising that Neil about this. This act by not only on procedure, but put jail safety in danger. According to Frank Dutton, is that once they complained, the whitehead should have been removed from the interrogation. It was also strange that the professor did not make arrangements with the principal for medical education. All this, in my view, amounts to an orchestrated cover. It was put to Ms. Professor by Council from Aggett family as follows. Mr. Bani, so you agree that in those hours of the meeting, our statement, in which statement you once a reckoning is just read off, and Professor, I agree. Evidence by both Daniel Hendra and John Edward and Lloyd demonstrate procedures in respect of banking items in the detainee itself was not judging by the inventory of items nailed cells after it. The question to be asked is why did the police allow that? Was not at any stage disclosed his ANC involvement to Neil, and between him and Neil it was all about union work, which was above board. Accordingly, there was no disclosure in the so-called 4-page document that could have made Neil to feel he had betrayed him. If there was such a document, he was never arrested and interrogated about it by the security police. Theron told the court that he believes that the document was nothing more than a fabrication by the security police to justify the death of Neil and exculpate themselves from any wrongdoing. In this reopened inquest, this court is called upon to make and record any findings that differs from the findings in the 1982 inquest. Section 17A3B reads as follows, I quote, "A judge holding an inquest that has been reopened in terms of this section shall record any finding that differs from a finding referred to in Section 16.2 as well as the respect in which it differs. The findings by Magistrates Court in this matter is a finding referred to in Section 16.2. At the end of the inquest, the magistrate made the request in the findings in terms of Section 16 of the Act, which I've already referred to earlier on. There is, in my view, sufficient evidence that was placed before this court that the conduct of the security police led directly to the death of Dr. Neil Aggett. Not only did some of those security police who testified in 1982 concede that they lied, but there is evidence which emerged during the TRC amnesty hearings by, amongst others, General Van der Merwe, that the security of torture and assault on detainees in the name of getting rid of ANC and communism. The version of the security police that Neil, on his own initiative, got hold of the Kikoi scarf, then climbed up the grill to a point where he was able to use both his hands to tie a knot around one of the bars after tying it around his neck, and then slid down, thus constricting his neck until he died. This must have taken place sometime between the hour of 2200 hours on the 4th of February 1982 and 1:30 a.m. on the 5th of February 1982. There is evidence supporting the view that statements by members of security police there is evidence supporting the view that statements by members of the security branch, the police officers investigating the death of Dr. Aggett, and the proceedings in 1982 were all part of an attempt to cover up or conceal the truth about how Dr. Aggett died. This view is supported by the unchallenged evidence of Frank Dutton, Paul Erasmus, Joe Nyampule, and Gideon Makete, all former police officers. This cover-up started first instituted to find out why so much contraband was found in Neil's cell, including a tie. Makete testified that this was totally against standing orders. The scene was tampered with in contravention with standing rules. Frank Dutton's view, which is unchallenged, is that police investigation failed on numerous counts. Firstly, when the investigation commenced, it was clear that the investigator had already adopted a view that Aggett had committed suicide. It is therefore not surprising that shortly thereafter, the top brass, which must have included Major Cronwright and Henry Miller, instructed Stephen Whitehead to go look for evidence that may support that conclusion. Hence the trip to Somerset West by Whitehead and Paul Erasmus to look for evidence at Aggett's school and his home for any evidence of Aggett being suicidal. The question is, if they were convinced that he committed suicide, why go all the way to Western Cape in search of non-existent evidence? Ms. Jill Berger, Aggett's sister, as well as Dr. Liz Floyd, his partner, all expressed their sentiment that there is no way that Neil would have contemplated suicide. This court has no reason not to accept that. Neil had made a detailed statement to Detective Blom on the 4th of February in which he sought that those who tortured him be dealt with. Now, why would he take his life instead of awaiting the outcome of this complaint? In Dutton's view, the conduct of Sergeant Blom, now officer, in immediately informing the suspects about the complaints of assault against him was reckless and improper. Hence, Eddie Chauke, a former security branch officer, told Dutton that Whitehead was so angry about Aggett opening a case of assault him in a rage, and he tore up the 28-page statement that Aggett had been working on for weeks. Chauke told Dutton that when he last saw Aggett, it was 3 p.m. on the 4th of February. Aggett was visibly upset and depressed. Whitehead, on the other hand, and the other white membership of the interrogation team said they were intent to resume further interrogation that night. Neil did not commit suicide. He was killed by members of the security police between 2200 hours and 1:30 on the 5th of February 1982. I have come to this conclusion because of the following unchallenged facts which appear here under. 1. Dr. Neil Aggett had been subjected to torture and sleep deprivation and no food for a period of 62 hours. His co-detainees, Ngwenya, Momoniat, Lirumo, and Naidu, testified how he looked like a day before on the 3rd of February. One of them said that he was like a zombie, while the other said he did not respond when greeted. In this weakened state caused by further electric shock after he had laid a complaint, there was no way that he would have managed to climb up the grill and tie the kikoi around his neck and the grill. There has been no explanation why only one fingerprint, being that of Neil, was picked up on the grill. If it was him going up, there would have been multiple fingerprints on the grill. The witness, Thabo Mutupi, testified that to climb to the top of the cell, Neil would have touched at least 3 or 4 bars. Mutupi noted that the deceased would have gripped the bar with his whole hand, leaving palm, thumb, and fingerprints. Professor Johann David Lobser, a chief government pathologist testifying in the 1982 inquest, was asked to comment if it is possible for the deceased to have gone up the grills himself. He responded as follows in Afrikaans. Ilakbare, die opzet hier is vir my die volgende, dat om hierdie eindresultaat te bereik, namelijk om die lichaam dan en hierdie houding te plaas, zekerlijk als daar nie 'n block en tackle beskikbaar was nie, so daar 'n hele aantal persone nodig gewees het. Ek sou reken ten minste 5 om die lichaam dan in hierdie posisie te plaas, op so 'n manier dat daar nie wesenlik naspeelbare fisiese versterings is nie. There is evidence that Neil had not been taking meals for a few days. This explains why he walked sluggish and did not respond to other detainees who tried to speak to him. Jabu Ngwenya told the 1982 court, as well as the reopened inquest, that physically Neil looked depressed. His shoulders were slumped. He walked with very little purpose. He dragged and shuffled his feet along. When Whitehead became aware that the case of assault and torture had been opened against him, he became infuriated and confronted Neil about that. Whitehead was more concerned about his career progression in the security branch and would not permit this complaint to stand in his way, more so that he, over 62 hours, had failed to get a confession or admission from Neil. In his view, the best was to get rid of Neil and eliminate him. After all, this was one of the security police methods. Whitehead knew that he had the support and backing of his superiors, like Major Kronwright and Tiene Swanepoel, also known as Roy Ress. The security police had access to the second floor cells at any time of the day and night. They could use the alternative entrance identified by architects, Savage, who testified that a detainee could be taken out of his cell through the gate that leads to the women's section of the second floor and then down either staircase to the lift without being signed out of the control office. He concluded that it follows that the security police would access the male section without passing through the control section. We now know from the evidence of Joe Nyampule that detainees will be taken out of their cells during the day for interrogation an investigation or would never be back in their cells at 1600 hours when day shift work. All right, Van Heerden testified in the 1982 inquest that on the night of the 4th February, Sergeant Achenbach arrived at his cell, opened it, and just shouted, greeting at him. Later that night, he heard a commotion. Auret repeated this evidence in the reopened inquest. Susan Jikelana saw Neil being carried shoulder high along the corridor in the same manner Muslims carry their dead. It was at that time between 2200 hours 30 and 1:30 a.m. that Neil was being carried back to his cell by members of the security police after he had been tortured to a situation of unconsciousness. Black security officers who were in possession of the keys to all the cells were, according to Gideon Maketa, instructed to lie under oath. Nyampule, one of them, testified in the reopened inquest that they were treated like children. They had to do as they were told. He says they were forced to turn a blind eye to the inhuman condition of detainees. Paul Setlo, who was in possession of the key to cell 209, including McPherson, who was in charge, did not testify in the reopened inquest. I have no hesitation that in the 1982 inquest, they were instructed by Cronwright and Miller to lie and tell that court that no security branch officer came to take Neil out of his cell that night. Dr. David Daidu, a specialist forensic pathologist testifying in the reopened inquest at the instance of Aggett family, told his court that medical evidence indicates that the physiological trigger to death was the stopping of the heart by the carotid sinus pressure by the ligature, which causes immediate cardiac arrest and or bilateral carotid artery occlusion. He says that this means that Aggett was alive at the time of suspension, and it was the suspension that killed him. However, he says this could have happened in a conscious or unconscious state. The same medical findings would result in a conscious or unconscious person. Dr. Naidu referred to 5 possible causes of unconsciousness, namely intoxication of some sort, concussion, traumatic, electric shock, induced hypoxia, stroke, anoxia from carotid arterial obstruction. Dr. Naidu added that these were 5 possible causes of unconsciousness. If such unconsciousness had occurred, it would not necessarily have been mutually exclusive to one another, and that a combination of one or several occurring together cannot be excluded. Electric shock and suffocation using a wet cloth was one of the methods that Whitehead and all other security officers were trained to use in order to get detainees to confess. Whitehead was frustrated after having subjected Neil to 62 hours of torture that he had nothing positive to report. The complaint against him just exacerbated the whole issue. When Neil could not recover his consciousness, they took him back to his cell and propped him up and hanged him. They then filled up his cell with all the good things in an effort to cover up. Magistrate Koza found that the evidence provided by the security police was unblemished. He concluded that evidence by the police late into the night Neil died was uncontradicted. This is hardly surprising because only security police officers were present and decided all forms of cover-up. This included the evidence of one Professor Jan Plomp, who, despite having never met Neil Aggett, concluded that Neil was suicidal. The evidence of Professor Charles Foster, a qualified clinical psychologist, and that of Professor Plomp, a qualified psychologist, contradict each other in respect of Neil being suicidal. It is surprising that Magistrate Koza preferred the evidence of Professor Jan Plomp over that of Professor Foster without any plausible or convincing reason. Plomp, amongst others, says that the issue of the telex was a trigger to commit suicide. We now know that no such telex existed. It was therefore surprising that Magistrate Koza concluded that he was satisfied that Plomp was an unbiased and honest witness, and yet said nothing about the evidence of Professor Charles Foster. The Magistrate Koza misdirected himself on a number of issues. For example, A, he curtailed cross-examination by counsel for the family. 2, he disallowed detainee statements that disclosed torture. 3, he nitpicked the smallest inconsistencies in the detainee's testimony. 4, he disregarded testimony by detainees because they were in custody for political crimes. Lastly, he accepted evidence by the security police without question. I have no doubt that Mr. Koza was biased from the onset in the conduct of the inquiry. He did not have an open mind to find out what happened between 2200 hours on the 4th of February 1982 and 1:30 a.m. on the 5th of February. His intention was to find out why Neil committed suicide and nothing more or less. his finding as to how Neil Aggett died and as to whether it was brought about by any act of omission falls to be set aside. It is strange that both Woensdracht and Dietlefs in their motivation application to be medically boarded said that Neil committed suicide on the following day after they interrogated him, which means the 31st of January 1982 or the 1st of February. Woensdracht himself, under cross-examination by Advocate Vani for the family, said that after he had interrogated Neil, had no suspicion that Neil would commit suicide. He does not know where Dietlefs got that because he did not tell the court in 1982. Mr. Paul Erasmus, in his evidence, told the court that detainees would be strangled until they were of the belief that they were on the brink of death. This, he said, would be done by placing a wet bag over the detainee's head and suffocating him until near unconscious. The evidence presented in this reopened inquest directly challenges the conclusions and findings of the magistrate in 1982 inquest. This court is accordingly tasked with evaluating all the evidence of the two inquest proceedings, taking into consideration whatever is left available of the 1982 inquest and the further evidence received in this quest. The magistrate concluded that Neil committed suicide by hanging himself as a result of the following reasons. One, that Neil was a man who was devoted to a cause who would, with a number of close associates, to achieve his goals. Two, that during his period of detention, Neil disclosed particulars of activities and, more important, the names of associates. Three, that these disclosures must have brought about a feeling of uncertainty about his future and the realization that steps could be taken against his associates. Lastly, that he had to face some of his associates and to admit the disclosures and anticipation of feeling rejection by them could not be excluded. An examination of the reasons preferred by the magistrate will demonstrate that the magistrate was at pains to at all costs exonerate the security police in the death of Aggett. Firstly, it is correct that Neil was devoted to the cause of workers. This is evidenced by the fact that he agreed to serve the union without being paid. I find no valid reason why this would be a reason for him to commit suicide rather than pursue the ideas of bettering the workers' conditions. The fact of the matter is that the security police could not accept that Neil decided on this cause rather than make lots of money as a doctor. One of the police officers said that in the reopened inquest. His sister Ms. Jill Berger, and his partner Liz Floyd, without mincing words, told this court that Neil would never commit suicide. He still had a long way in enhancing his medical qualification. Sergeant Blom-Fesser agreed with this. Secondly, the magistrate says one of the reasons is that Neil disclosed particulars of the activities and also named associates, and this caused him embarrassment, therefore decided to take his life. In the first place, this is speculation by the magistrate. There was no evidence placed before the 1982 inquest as to what Neil's activities were, which he disclosed, which were unlawful. Neil told them that he was a member of a legal trade union and denied being a member of any banned organization. In any case, Neil must have mentioned the name of John Deron and that of Oscar Mpete because they were union officials. If there was anything sinister about that, the question remains why no arrests were made pursuant to that disclosure. The reason that Neil anticipated a feeling of rejection from his close associates for having disclosed their names is, in my view, speculative and nonsensical. According to Fesser and Dietlefs, Neil made the disclosure on the 30th of January 1982. The question is, why would he then wait 4 days, then decide to commit suicide, and in fact, after laying a complaint of assault against Whitehead and other police officers? Similarly, the reason that Neil committed suicide because a friend could not provide him with a radio in the cell is, in my view, laughable and has no merit. Despite overwhelming evidence by detainees in the 1982 inquest about the various forms of assault meted out to them, the magistrate preferred the evidence of police, and in one sentence, he said the following, I quote, I have already dealt with the possibilities ingrained in allegations of assault, sleep deprivation, and other forms of ill-treatment, and concluded that nothing of that kind is proved. The finding that Neil consented to be deprived of sleep for 62 hours boggles one's mind. It is so far from the truth and reality that it falls to be rejected with the contempt it deserves. The magistrate, without further inquiry, accepted the lies from the police. If Neil consented, then why did he lay a complaint on the 4th of February 1982? The evidence of assault and other forms of torture of detainees presented before this reopened inquest, especially by Prima Naidu, Reverend Frank Chikane, Jabu Ngwenya, Susan Jikelana, and Barbara Hogan, is so overwhelming that the denial and lack of knowledge thereof by security officers, namely Chauke, Dietlefs, Winsdracht, Fesser, and Swanepoel, who all testified in the reopened inquest, is disingenuous and amounts to an act of cover-up. This court accepts on the basis of overwhelming similar pattern torture on other detainees that Neil Aggett was tortured, which torture included physical assault. It is common cause that Neil Aggett was in a weakened position since the long weekend of interrogation and torture. One detainee described his movement as sluggish and shuffling. He also said to another detainee that he had been tortured and that he cannot take it anymore. Dr. Naidu, an expert pathologist, testified that Neil must have been unconscious when being popped up the grill, either through suffocation, electric shock, or intoxication of some sort. Paul Erasmus testified that security police routinely covered up for each other. He cited the case of Standards Bupape, who it later appeared in the TRC hearing was killed at John Foster Square by electrocution. It is therefore clear that the death of Dr. Aggett was a big cover-up of the truth, and this involved all the security police officers who were there on the morning of the 5th of February. This view is supported by the evidence of Frank Dutton and Erasmus. Major Cronwright took it upon himself to write out statements for the black police officers so that their evidence should fall in line with the general scheme of cover-up. Sergeant Joe Nyampule testified to that. Evidence of cover-up is further supported by the sloppy investigation conducted, as well as the failure to hold administrative inquiries in terms of the Police Act concerning certain breaches of protocol and police orders. Frank Dutton testified that at the time the investigation commenced, it was clear that the investigators had already adopted a view that Aggett had committed suicide. This, he said, fell short of the required level of impartiality, which requires an open mind as to the cause of death. In his view, the selected investigator, Captain Carl Victor, who was attached to the detective branch at John Foster Square, was unlikely to act independently in the face of senior officers such as Brigadier Roy Reswanepoel and Henny Miller, who were overseeing the investigation of the death of Neil Aggett. In particular, Brigadier Roy Res took charge of the death scene in cell 209 in the early hours of 5 February 1982, even before the arrival of any forensic pathologist. Frank Dutton reminded this court that Brigadier Roy Reswanepoel interrogated Suleiman Saloji on the day he fell to his death on the 7th floor of Grace Building in Johannesburg on the 9th of September 1964, and also that he interrogated James Linkwe on the day Linkwe allegedly hanged himself in March 1969. There are a number of issues and events which, if the magistrate had applied his unbiased mind to the facts and evidence, would have indicated that the police version was a lie and a sham meant to cover up the truth. One of the most obvious is the non-disclosure of the 4-page document wherein Aggett is said to have incriminated others. And second, most glaring is the mission by Lieutenant Whitehead, who was a suspect to the Corps, together with Erasmus on a fishing expedition aimed at coming with evidence of Aggett's possible suicidal tendencies. Mr. Frank Dutton makes the point which, in my view, sums up the involvement of the security police in the death of Dr. Neil Aggett. That is, that the gap in cell visits during the late night of 4 February and early morning of 5 February may not have been a mere coincidence. This, he says, may have been orchestrated to permit the death scene. There is ample evidence and indication that support this view. I have dealt with same elsewhere in the judgment. The evidence of Dutton and Erasmus corroborated that of detainees that it was general practice for the police to torture detainees to a point of death. In the event death occurs whilst in detention, a cover-up story would be devised and implemented so as to shield security police from blame. According to Dutton and Erasmus, the cover-up story must be handled by a unit within the security police known as the resident sweepers. In conclusion, having heard all the evidence, I've come to the conclusion that Dr. Neil Aggett was killed by members of the security branch. The evidence of Coleman, supported by that of Jabu Ngwenya and Susan Jikelana, is vital. It is clear that something happened between 2200 hours on the 4th of February 82 and 1:30 on the 5th of February. The fact remains that Aggett was assaulted and tortured. The suspects were known to him, and he told Sergeant Blom who they were. Those suspects included Lieutenant Whitehead, who became angry and promised to carry on with the further investigation. Lieutenant Whitehead was extremely obsessed with getting his way with Aggett. After Martin Odier had given a report early in January 82 to the effect that he could find nothing to justify detention of Aggett, Whitehead removed him from further involvement and directed Odier to go back to East London. It is also clear that the claim by Dietlef, supported by Woensdracht and Whitehead, that Neil produced a 4-page document in which he incriminated his comrades was nothing but a fabrication used to justify the reason why he committed suicide. Warrant Officer Dietlef was probed as to the contents of that apparently explosive and sensitive information, was unable to give any precise details of what it contained, not only in this reopened inquest but also in the 1982 inquest. The subsequent telex to said office laying that 4-page sensitive document was never produced. It is therefore clear that this was a fabrication concocted to explain the 1982 inquest, some kind of basis that supposedly led to Aggett taking his own life. This was followed by a well-orchestrated cover-up engineered from the top police structures within the security police. It is clear that Dr. Aggett had had enough of the torture and made a complaint on the 4th of February 82, and judging by his character, he was prepared to proceed with the claim, and it is for that reason that he died within 15 hours after making the statement. When Liz Floyd asked Dietlef who was killed, Dietlef responded, "Someone close to you." It is significant that Dietlef did not tell Liz about suicide. It therefore means that he knew that Dr. Aggett had been killed. It's also not surprising when Whitehead was asked if he will be applying for amnesty in respect of the death of Neil Aggett. He responded to Dr. Pretorius, one of the TRC investigators, that he will not apply for amnesty, and as regards Neil's death, he blamed Paul Erasmus. He told the investigators that Paul Erasmus strangled Aggett with a wet towel. Accordingly, it is my well-considered view that Dr. Neil Aggett did not commit suicide. He was killed by members of the security police at John Foster Square. There is evidence implicating Lieutenant Stephen Whitehead in the killing, duly assisted by unknown police officers. There is also evidence that officers Visser, Dietlef, Chauke, Woensdracht, and Swanepoel participated in the cover-up in 1982 and in this court by denying knowledge of assault and torture. I recommend that investigation be undertaken in this regard. In conclusion, my findings are as follows. In the result and in terms of Section 17A(b), read with Section 16(2) of the Act, this court finds as follows. 1. The deceased is Dr. Neil Aggett. 2. Cause of death was hanging. 3. Date of death, 5 February 1982. 4. The death was brought about by acts committed by members of the security branch stationed at John Foster Square, amongst them Lieutenant Stephen Whitehead and Major Cronwright. I hand down the judgment. Court adjourns.
All right, and so we come out of that judgment into the reopening of the inquest into the death of Dr. Neil Aggett. As you heard there, the judge being very... an investigation into, among others, Stephen Whitehead and police officers there.
Guys, can we just come together?